Hi, my name is Scott McVarish. I'm the Principal Attorney of the Immigration Law Office of Los Angeles. We're going to talk about provisional waivers, otherwise known as stateside waivers. These are special waivers that have only come online in April of 2013. So if you haven't heard about them, it's because it's a very recent change in the law. But it's an important change, and it's one that can help a tremendous amount of families here in the United States. Here's the situation you would need in order to have the benefit of a provisional or stateside waiver. First, there's a U.S. citizen in the family, and that U.S. citizen is able to petition for the foreign national or for the immigrant. So for instance, if you're the U.S. citizen and your spouse is an immigrant or foreign national, then you can apply for the provisional waiver under certain circumstances, which we'll discuss. So first, they have to apply for the I-130. You as a U.S. citizen, if you're over 21, can apply for your child, you can apply for your spouse, or you could apply for your parents. That's number one. You have to have the I-130 approved. That can take up to 6 months, meaning you've got to go through that entire process before you can even apply for the provisional waiver. If you have an I-130 that's already been approved, we may be able to convert that for your foreign national spouse, parent, or child. Secondly, you need to show extreme hardship. What is extreme hardship? Well, it's not precisely defined, but it's more than I'm going to miss my spouse or I'm going to miss my parent. Unfortunately, the U.S. government discounts that. They consider that a hardship, but it's not an extreme hardship. What they're looking for is a financial or an emotional or a health hardship that goes above the normal type hardship. So for instance, let's say you have a mortgage on a house and you're going to lose that house without your spouse. That would contribute towards extreme hardship. If you have a physical disease or disability and you rely on your spouse or the foreign national to help you overcome that or to get you through the day, that could be extreme hardship. If your child is in school and is offered services such as special education services or maybe even honors services that they wouldn't get in the home country of the foreign national, that might rise to the level of extreme hardship. We may need to get you a psychologist who gives you a report to show why you personally will have an emotional reaction that goes above and beyond the normal emotional reaction of losing your spouse or your child or your parent to deportation. So we need extreme hardship. Now, what does it cure? Well, unfortunately, if your spouse, your parent, or your child has a deportation, a final deportation order, and they return to this country, it won't cure that. If they have some type of criminal issue, it won't cure that. What it does cure is an unlawful entry and unlawful presence. So for instance, if your spouse, child, or parent came a few years ago or many years ago unlawfully, they went through the desert, it'll cure that. If they went through an inspection point with a false document, it won't help that. That's a different type of waiver that would be necessary, and they would probably need to spend more time outside of the United States to get that waiver. One thing to note is if they in fact came through an inspection point and say were waived through, so they were in a car perhaps in the back seat, their cousin or uncle or friend was driving, and they were just waived through without being asked for an ID, that is a lawful entry. We can get you a waiver for that, possibly, or we'll be able to apply for your adjustment of status through a law called the matter of qui lontan. That's the case law that we use for these situations. That's for another video discussion, but make a note of that and talk to us about that if it applies to you. Back to the provisional waiver. So it will cure unlawful presence if you've been here unlawfully for more than 6 months, all the way up to 60 years, and it will cure your unlawful entry. So that's what the provisional waiver is for. These cases are very doable. It will mean you can get your waiver while you're in the United States, and then you just have to go to your home country to pick up the visa. So you may be out for a few days, a week or two at the most, instead of a year or up to 10 years if you don't have the waiver. Very important change of the law. Prepare now. There's a lot of people applying for it. Even if you're not sure you're ready, now's the time to begin getting your documentation. Now's the time to establish a relationship with an attorney. You can call our office and we'll talk to you and we'll help you through it. Our phone number, 800-792-9889 or immigrationhelpla.com. Thank you very much.